Hi. We are from DIA3C.
Please enjoy our video till the end.
Don't forget to like and subscribe, guys.
Section 2D Contracts Act 1950. Consideration. What is consideration?
Consideration is a something bargained for and received by a promiser from a promisee. Common types of consideration include real or personal property, a return promise, some act, or a forbearance. Consideration or a valid substitute is required to have a contract.
Consideration, an easy way to understand, is that each party has to give something and to get something.
Section 26 Contracts Act 1950. An agreement without consideration is void unless
A. Promise made on account of natural love and affection between parties standing in near relation to each other. B. Agreement without consideration is valid if it is a promise to compensate for something done for the promiser. C. A promise to pay a debt barred by limitation law is valid if it is made in writing and signed by the person to be charged therewith or his agent.
What is an example of the validity of a consideration?
Consideration may move from a person who is not the promisee. It means that the act or forbearance may be done by the promisee himself or any other person on his behalf.
A father gifted the whole of his property to his daughter on the condition that she should pay an annuity, annual payment, to her uncle, father's brother. On the same day, the daughter entered into an agreement with her uncle and agreed to pay the annuity. Later on, the daughter refused to pay on the ground that the uncle did not give any consideration to her. The court held that the consideration was paid by the father on behalf of her uncle. Therefore, the uncle was entitled to recover the annuity. China v. RABIIE. Thus, from the above discussion, it should be clear that a stranger to consideration can file a suit to enforce his right. Under English law, however, consideration must move from the promise and not from any other person. It means that under English law, a stranger to consideration cannot file a suit to enforce his right.
Consideration must be sufficient but need not be adequate. It means consideration must be having some values, whether it appropriates in order to meet the return of the agreement.
Consideration must be sufficient but not necessarily sufficient if Mr. A promises to sell his car to Mr. B for Rm20.63. The price of Rm20.63 is some value and therefore sufficient and valid consideration for Mr. A's promise to sell the car. It does not matter in this case that the price of Rm20.63 is clearly not enough by a car. In this case, the court will not investigate the value of the car to see if Rm20.63 is a reasonable price for it. This is the meaning of the statement that judgment does not have to be sufficient.
An invalid judgment is not a good judgment. Section 24 of the Contracts Act 1950. Every consideration or objective of the agreement made by the parties in the contract is valid unless A. Prohibited by law. B. Is of such a nature that, if permitted, it would be unlawful. C. It is fraud. D. It involves or implies injury to person or property another. E. The court considers it immoral, or against public policy.
What is not consideration? 1. Promise for love, affection, or to maintain a relationship. 2. Gift with condition required or given. 3. Promise of the gift.
Hello everyone. My name is Mohammed Nazrin Iqmal. Today, we will learn about topic capacity, under the law of contract. Under Section 11 Contract Act 1950, every person is competent to contract as long as of the age of majority, of sound mind, and is not disqualified from contracting by any law to which he is subject. A person who is not of the age of majority has no capacity to contract. A person is of the age of majority at attaining the age of 18 as stated in Section 2 Majority Age Act 1971. A person who is not of the age of majority is referred to as minor. An agreement made by a minor is void ab initio. In India's court decision in Mohd v. Mohd as goes 1903, appellant gives credits to respondent, a minor. Respondent charges a house as a security. Respondent, through her mother, sought order from court to declare that the charge is invalid because lack of capacity to contract. The courts grant the order. Malaysia's court in Tan Hee 1 vs Tabun Keat 1934, upholds the decision in Mohd Bibi vs Mohd as goes 1903 when decided that a transfer of title to an estate by plaintiff, a minor, is void. In a situation where a minor purposely misrepresent the other party about his capacity, his action does not make the contract to be valid. In Natasan vs Thanalechemi and Anor 1951, a minor contracted with a plaintiff after making false statement about his age. When sued, he used of lack of capacity as reason. Plaintiff claimed that defendant may no longer use the reason because defendant made false statement of his age. The court held that misrepresentation does not obstruct the minor to use lack of capacity of defense. However, there are a few types of agreement when entered into by a minor is treated by law as valid contract. These agreement are: 1. Agreement in relation to marriage, divorce, dower, adoption, religion, and religious rights. In Rajeshwari and Anor vs Balakrishnan and ORS 1958, defendant is Hindu. He broke a promise to marry plaintiff, also a Hindu. When plaintiff claimed damages for breach of contract, court granted the claims even though plaintiff is minor. Defendant broke contract of marriage which is made under normal practice of their customs. 2. Agreement of necessities. A minor is responsible to agreement if goods or service provided under the agreements is of necessities. The term necessities is explained in England's SOGA as goods and services reasonably necessary to a minor's actual requirement. For example, food, shelter, medical services, clothing at the time the sale was made. The type of necessities also depends on a minor's condition of life or standard of life. In Nash vs Inman 1908, a tailor sued a minor to whom he had supplied clothes, including 11 fancy waistcoats. The minor was an undergraduate at Cambridge University. It was held that although the clothes were suitable according to the minor's station of life, they were not necessary as he already had sufficient clothing. 3. Agreement of apprentice or employment. A minor is bound by a contract of apprenticeship or employment as long as it is in the whole, for his benefit. In Doyle vs White City Stadium 1935, a minor was bound by the terms of this agreement with the stadium when he agreed to undergo a training to be boxer. 4. Agreement of a scholarship. In Government of Malaysia vs Gurcharan Singh 1971, Gurcharan received scholarship from government to attend trainings as a teacher and for that he is to serve with government for 2 years after graduated. Gurcharan left before full term. When sued, he claims that contract is void. He was lack of capacity during that time. The court held that education is a necessity to a minor. Gurcharan is in breach of contract. Under Section 12(1), Contract Act 1950, a person is said to be of sound mind and if at the time he makes IT, he is capable of forming a rational judgment as to effect of the agreement upon his interest. Individuals who are clearly intoxicated by alcohol or otherwise are generally deemed not to be able to enter legally binding agreements. Such person have no agreeing mind, though similar principles apply as to those who are otherwise incapacitated. A person who is of unsound mind enters into a contract while he is of sound mind, the contract is valid and vice versa. That is the end of this.
Assalamualaikum and hello everyone, I am BATRISYIA AISYAH and today I'm going to explain about discharge of contract. Discharge of contract. When a contract is discharged, it is actually terminated. The contracting parties are free from further obligation and under the contract. We have 4 types of discharge. Discharge of breach, performance, consent, and frustration.
What is discharge by breach?
Promisors fails to perform the promise of the obligations which a contract imposes. It occurs when a party to the contract does not fulfill his contractual obligation or by his own makes it impossible that he/she should perform his obligation under it.
I want to make a contract with you to perform at a concert to be held on next week.
Okay, I agree to perform at the concert.
I could not attend the concert because I have an emergency. I'm sorry.
Okay, noted, thank
From
you.
the cases, defendant breach contract. So plaintiff sue a defendant for the compensation.
What is discharge by performance?
Both parties WHO get into contract has successfully performed as they promised.
If there is the time stated in the contract they need to perform according the contract.
Well, if no time fixed, the contract need to be performed within reasonable time.
Naqib has agreed to sell his car to Ilyasa for Rm60,000 and Ilyasa has agreed to pay the car.
When Naqib and Ilyasa has successfully performed their contract is categorized as be discharged.
Discharge by consent.
Both parties WHO gets into contract. Agrees not to perform the contract. Discharge of consent can be by:
First, replace old contract with a new one. Second, by recession. Third, by alteration.
The seller has sold his iPhone to the buyer at Rm2500.
However, they have changed their mind not to buy and sell the iPhone because of the agreement. Their contract has been discharged. Discharge of frustration. They have two types of frustration. First, contract itself impossible to be performed. Second, contract becomes impossible to be performed after IT has been made.
Stars, is that possible?
No, my dear.
Since the contract itself is impossible to be performed at first place, so it is being categorized discharge by frustration.
Situation. Medina is the famous singer. She has rent a town for her concert. An agreement has been made between her and officer.
However, on the day of the performance, the town hall caught on fire.
Unfortunately, she cannot sue the officer because she not being able to perform. Why has this happened? Because the contract was void due to the destruction of subject matter of the contract, which is in this case the town hall.
That's all from me. Goodbye, have a nice day.